Good afternoon, everyone, and greetings to all those who have joined from different jurisdictions. A very warm welcome. May I please begin today's session by welcoming our eminent panelists. Before I introduce the topic of the day, I would like to briefly introduce our panel today. Our first panelist today is Mr. Pradeep Sancheti, Senior Advocate, Bombay High Court. Mr. Sancheti regularly presides as a mediator in various commercial disputes. He also has vast experience in matters related to companies law, property law, wills, probate, private commercial laws, shipping matters, among others. He also regularly leads and appears in complex commercial litigations, arbitrations, and disputes related to infrastructure projects and banking litigation across the country, including the Supreme Court. Mr. Sancheti, very warm welcome to you, sir.
Thank you. Thank you.
Our next panelist is Mr. Stefano Cardinale. He's a registered lawyer at the Barcelona Bar Association and the Rome Bar Association. He practices as an international business lawyer, professional mediator, negotiator, and ADR consultant for business. He has an extensive practice of international commercial ADRs, and he provides tailor-made conflict management systems to domestic and foreign companies. So with this great experience, we are definitely going to benefit from it. Mr. Cardinale, welcome.
Thank you. Thank you very much.
I also wanted to share a small thing with all our viewers. Both the panelists today are also my gurus in real life. So when I was training for mediation way back, Mr. Stefano was one of the expert trainers, and it was a great experience, sir.
Thank you.
As far as Mr. Sancheti is concerned, he has trained me on day-to-day basis when I have appeared before him as a mediation counsel before him. So it has been a great learning experience, and I look forward to your views from both of you on this discussion today. With this, may I just briefly touch upon today's topic? Mediation, as we know, is fast emerging as an effective alternate dispute resolution method. A fair number of commercial contracts have amicable resolution clauses, and mediation fits right in the middle there as a very effective mechanism for amicable dispute resolution. Also, given today's times, where we are all in a lockdown or semi-lockdown situation, we need an effective system to resolve disputes. And those disputes cannot wait for prolonged time, and we don't know how long this situation will remain. Given this, even our court system and arbitration platforms are trying to move online. But it always is a struggle, and we are still trying to find our feet there. In this scenario, mediation, which can also be done very effectively virtually, can be a great tool to help the industry, to help the people in dispute. So we feel that this discussion will definitely give us something to take home as to how we can use mediation in our commercial disputes, in our other disputes in day-to-day affairs. For structure, we have divided our session in two parts. Part one is to understand what mediation as a concept is, how effective it has been in resolving commercial disputes in the past, and what can we do with it today. We would like our panelists to discuss the increased relevance of mediation in today's situation, identify the legal framework in place, and how we can use mediation in domestic and international perspective. In part two, which will be more in form of a question answer session, we would like to understand how we can use mediation as a viable method to help parties resolve their disputes in these situations today. In this, we will also examine as to how we can use mediation as an ODR tool, online dispute resolution tool. With this, I will invite the panelists to share their initial views, and you, the viewers, are very welcome to put your questions in the chat box. We will, after the session, we will try and invite the panelists to respond to the questions. And wherever we cannot respond to the questions, please feel free to write to us. We will try and do our best to respond to each question. With this, and without taking more of your time, may I now invite Mr. Sanchez to give his opening remarks, please. Sir, over to you.
Thank you, Chakrapan. Good afternoon to all the friends from India, and salutations to people in different time zones. Global we are, even in these times, though we are all sitting in different places and confined to our houses. Mediation, as we know, is one of the techniques of alternate dispute resolution, ADR. And I have just learned ADR has now become ODR, as Chakrapan said. In India, mediation is statutorily recognized. Rather, amongst the 3 or 4 tools which are mandatorily prescribed, mediation is one of them. But interestingly, there is no law enacted governing mediation. Before I go into details, let me just in very simple words tell you what I think mediation is about. Mediation is not about deciding who is right, who is wrong. Mediation is not judgmental. Mediation is about resolution. If you have 2 or 3 children fighting in your house, and if you have this enviable or unenviable position of trying to resolve it, you don't end up telling anybody who's wrong, who is right. You just then bring them around and rest works on its own. Mediation is somewhat similar to that. Nobody is judgmental, including the mediator. We are all lawyers. We are all interested in resolution of disputes, resolution of situation, and giving a happy ending to the client. But we all know that from the techniques that we have followed, including arbitration, which is considered an alternative ADR method, it is time consuming. In courts, we have many other constraints. Sometimes cost itself is a big constraint. We have various difficulties. And above all, the delay, not being able to do it speedily, is a big challenge. Now let's connect it to the present times. We are in COVID times. We are all listening about Corona maybe 1,000 times a day. Medical fraternity at large is trying to give you a solution, but they haven't got you a medicine, a tablet, or a vaccine, which is you take it and you are cured. So the best thing is to work around the solution, but you don't have a solution directly. Now imagine if this whole process continues for a long time. You have lockdowns, you have deaths, you have economic losses. Translate the same thing in business, translate the same thing in commercial disputes. If the disputes go on for a long time, if there is no resolution, if there is no panacea, then you may have lockdowns, you may have economic slowdowns or economic problems, and you may have other businesses suffering sometimes almost virtual death. So mediation is a tool which can be effectively used to get over this problem. In fact, the age-old saying, and which applies to all kinds of disputes, is justice delayed is justice denied. So mediation is something which can get you justice in every form, including no delay. I would suggest, because once you take it as a means of alternate dispute resolution, the parties and the lawyers all must approach mediation with objectivity and with a positive frame of mind, because the problem very often, or the dispute very often, or the agitation very often is maybe just a ego issue, maybe a case of misunderstanding. Because when the matters come to courts, and when we end up arguing them sometimes for hours and on, sometimes for days and on, we know nothing is in black and white, or most often it is not in black and white, it's in shades of gray. So, and between one judge and the other, and one court and the other, and the appeal court, the views can differ substantially. So, if people approach the whole process with an open mind, and the lawyers impart objectivity to the whole process, the lawyers, in that sense, have to behave more like moderators rather than the one whose cause they are espousing, otherwise is lawyer. The system would work beautifully. Coming back to the legal framework in India, Section 89 of CPC, which mandates following the ADR processes, in which gives you 4 processes, including arbitration, conciliation, mediation, and the lok adalats. Mediation is one of them. So, under 89, it's almost mandatory. Mediation is recognized, but at the same time, the law is framed, as we know, is Arbitration and Conciliation Act. It doesn't deal with mediation per se. Mediation is not dealt in that Act of 1996. It is following the Unilateral Code. So I suppose that would be the position in many countries, not necessarily in Italy or otherwise. Maybe some countries have separate law dealing with mediation, but in India, we do not have it. The lack of parliamentary law is sought to be covered by framing rules by different states. Maharashtra has also framed rules, and those rules have been notified. So you have something like subordinate legislation covering the field of mediation. Now, let me just tell you very, very briefly how I see mediation as, and that probably is the essence, and that probably will give you a focus on what Mr. Chakrapani has said. What is the theme of today's discussion? Mediation is essentially by agreement of the parties, is by consent of parties. It's a consensual process, which means you cannot start mediation unless both parties agree. You cannot continue mediation unless both parties agree. Any party is free to withdraw at any point of time. You cannot have any settlement unless both parties agree. Nobody can foist its or his views on any party, including the mediator. Nobody is allowed to be judgmental. Mediator cannot say you are right, you are wrong, and therefore this result must follow. Now, if that is what it is, then you might wonder then that how does it work? It works in a very simple fashion. Mediator is free to meet all the parties, any party, individually or collectively. Unlike in court or in arbitration where natural justice demands are different, that those rules do not apply there. The purpose is mediator must know the pulse, must know where it hurts. Why is each party finding it difficult to come to terms? So that then he can use that information, that knowledge, of course selectively, in his own way, taking parties into confidence to bring parties together. So it is all with consent. Mediator is essentially a guide, a facilitator who will try to iron out differences, who will try to help people communicate with another, so that who comes first, who bends first, whose ego comes, who has hurt me first, all that is somehow taken care of in that communication process. Just as they say, there is no problem in the world which can be solved by sitting together. So mediation is a platform where everybody sits together with the intent to solve it. And that itself makes 50% of the job done. The other 50% is with cooperation of parties, lawyers, consultants, etc. Let me tell you one more thing, which probably will help all of you the best, unless you've experienced it otherwise. All communications made in the course of mediation are confidential. So if you share any information orally or otherwise, that information is confidential. Supposing there was no settlement, that information cannot be used as evidence in any court of law. So that makes the process that much more transparent, that much more easy for people to communicate and to come to terms. Therefore, I see that in today's times where moving from one place to the other, physically assembling and going to court or going for a hearing is getting increasingly difficult. Mediation, and that too not just in ADR but in ODR form, is a great tool which you should all use frequently so as to give positive results to our respective clients. Thank you. Thank you very much.
Thank you, sir. Thank you for this very in-depth overview. It sounds contradictory, but it was the experience was very in-depth. Thank you for encapsulating it in such a short time. Thank you so much, sir. Mr. Cardinale, may I now request you to give your opening words, please?
Yes. Thank you very much for inviting me to this webinar, first of all. And I would say I would focus my view of mediation in a few things that maybe because we are very developed regarding mediation laws in Italy and Europe, and I will go to this later on, we are sometimes we are forgetting some my lawyers colleagues and judges and all the people that are professionals that are working on mediation. Sometimes we forget the very basic elements of mediation because we have a very developed law on mediation, so we are forgetting our roots sometimes. So I would focus on very first of all, mediation is a facilitated negotiation. Sometimes still today I hear from colleagues, lawyers, that they confuse mediation with arbitration. So if arbitration is a private judgment, mediation is a facilitated negotiation. So basically, it's like a negotiation between two parties with a third neutral party facilitating it, who is merely only facilitating the negotiation and not taking any decision, not imposing any decision, not even suggesting any decision or any settlement. Then when I say this in other forums, then lawyers, basically mainly lawyers from law firms that work mainly on commercial disputes and on commercial settlements, so lawyers who are used to negotiate, so they object that, so what is mediation for? Why do I need mediation if we already negotiate 70% of our disputes, commercial disputes, are negotiated? And that is a very important issue that we need to address, because as a negotiator, I'm also a negotiator, and I do negotiate on behalf of my clients. And sometimes I also give them consultancy in mediation process. So I assist them as a lawyer in mediation, not as a mediator. I find very helpful the role of mediator, because as a negotiator, you have to negotiate for your client. As a mediator, you have the great power of being neutral. So that is it's a challenge, because you must be neutral, otherwise a mediation will not work. But it's also a very strong power, because when I negotiate on behalf of my clients, I need to be the warrior on the side of my client, right? I need to protect my client interests, and I have some limitations due to my role as a negotiator on behalf of a client. When I mediate, I don't have those limitations. So the third neutral party who helps the party and facilitate the party to negotiate is very helpful, especially in commercial settlements, where most of times I experience that the disputes are related to some like commercial, for example, or industrial secrets, commercial policies that cannot be disclosed to the other party, or problems related, internal problems of the company that cannot be disclosed to the other party or to the public, because they will create damage to the image of the company on the market, especially if we're talking about big companies. So in those cases, the help of a mediator is essential, because in separate sessions, parties can disclose some certain issues to the mediator without the mediator disclosing it to the other party. But if the mediator gets to know which are the real underlying issues of a dispute, then he can help the parties and drive the parties to a solution without even disclosing those confidential information. This is a very critical and an important issue in commercial mediation. So this is the real help that a mediator can give in a commercial, international commercial setting. And I found it, in my experience, much easier to solve an international commercial dispute through mediation than through a simple negotiation between the parties. Then one more issue that is very important to address. Mediation is not about being it is an amicable solution, an amicable way of managing the dispute and trying to solve it, but it's not about being good to the other party. I mean, it's not only about peace and love, as some promoters of mediation say about it. Mediation is helpful if, and in those cases where protecting the interest of the other party means that you are protecting also your interest. So mediation is, I would say that in a commercial setting, we have to look at mediation in forgive me for the word, opportunistic way, meaning that in those cases where mediation is helpful for me, then it means that by being collaborative to the other party through the help of the mediator, I will primarily do my interest. So my interest in a commercial setting is very important. So it doesn't, because in old times where mediation were only mediation started in the years 70s and those years in United States, it started at the beginning to be used in family matters, right? Where it is much more evident that you have to work on the relationship, because the relationship is stronger than in a commercial setting, right? And so in those settings, then it was seen as a peace and love tool, right, to solve disputes. But in a commercial setting, we have to think that dispute. Mr. Sanchetti said a very, very interesting thing before. He said there is no problem in the world that cannot be solved by sitting together, right? So problems, even if we see that a dispute between two big companies, right? It seems that there is no relationship in there. It seems that there is no emotional issue in there. But at the end of the day, the problem is not created by the company. Problem is created by human beings. So conflict is something that is between human beings. So even in the most complex commercial disputes, there will be emotions, there will be like underlying issues that are based on career expectations, money, emotions of the people involved in this. So even in commercial settings, mediation in some disputes is the most effective tool to solve them, especially in these times where we are locked down in our houses and courts are overwhelmed with or will be overwhelmed. In Italy, courts are already open, but they are completely overwhelmed by the cases because they've been stopped and locked down for 2 months. So in this particular moment, mediation happens to be the most effective tool for this resolution. One more thing and last thing, I think that for mediation there is no need of any law, basically, because actually mediation, I mean, if both parties are willing to mediate, then actually you have a good mediator, then there is no need of any law. But even in this scenario, we have experienced in Europe, all over Europe, since 2008, that we have a European Union directive uh, uh, establishing mediation as a tool for dispute resolution in the internal market. And then we have had all the member states have adopted their own legislation, internal legislation under the directive number 52 of the European Union. Since then, we have experienced a boost in mediation. We have had in 2010 in Italy, we had 1,000 mediation providers licensed by the Ministry of Justice. So before we were only, my mediation provider started in 2006. Before we were like 50, 60. Then in 2010, when the European Union directive and the Italian national law came into force, with the number of mediation providers boosted and the number of mediation were really high. So a law, it is very helpful, although there is actually no need of a law to mediate and for the effectiveness of mediation. A law is very helpful to establish the enforceability of an agreement reached through a mediation process. This is the main issue, because here in Italy right now, if you mediate and you reach an agreement, the agreement is fully enforceable. So it's much stronger than a contract. So that has been very helpful, because parties and citizens have started to recognize mediation as a tool beside arbitration and beside litigation. So I will conclude by now with that. So
Well, thank you, Stefano, for that very lucid international view and the relevance of enforcement in terms of mediation and mediation agreement. Now this moves us to the second part of our session today, where we are going to draw upon the vast experience of our panelists and enrich ourselves from their experience in this field, and also seek their views on how we can use mediation in today's time. So beginning with you, Stefano, you mentioned the interesting practice in Italy as to how mediation is a part of the legal system and so on. Before that, I wanted to check with you one thing, where there is this bit of confusion when it comes to other jurisdictions. The confusion with regard to conciliation, mediation, and settlement, negotiation, they are being interchangeably used. Whereas in some jurisdictions like ours, we understand mediation to be different, conciliation is a different process, arbitration is yet another fully developed process. So these are three different ways of resolving dispute on alternative platform. However, when we see elsewhere, it becomes a bit confusing whether it is mediation means conciliation or conciliation means mediation. So, what are your views on that, and what is your experience with regard to other jurisdictions and how this is done, and also the process how it works in your country, that is Italy, as to how this mediation and conciliation work and how it is understood?
Right. Yeah, thank you for the question. Very, very good question. Actually, the pure theory of mediation says that mediator should be only a facilitator of the dispute, right? Of the negotiation. So a mediator should not suggest any solution to the parties, right? So I interpret mediation as a process in which the mediator is only a facilitator of the negotiation, but he or she doesn't suggest any solution, doesn't use expertise on the field of the dispute to suggest to the parties how to resolve their dispute. Right? While in conciliation, what we intend as a conciliation is a process similar to mediation, but where the conciliator is an expert on the field of the dispute and delivers actually to the parties a suggestion on how to solve their dispute. Maybe a big time lawyer or a retired judge with a lot of experience in the field. And so through that and because of that experience, the parties choose that particular conciliator to deliver a suggestion on how the dispute should be resolved. Given that, I agree on the fact that many times these two concepts are completely used in a way, interchangeable way. If we think, for example, at the Italian law of 2010 allows, even though the law is the law on mediation, not on conciliation, it is called mediation, and because it comes after the European Union Directive of 2008, which establishes mediation as a tool of dispute resolution in the internal market, right? So the Italian law is on mediation, but nevertheless, Article 11 of this law allows the mediator, if he believes that there is no solution that can be reached, to stop mediation and deliver a written proposal of conciliation that can be accepted or refused by the party. But the parties have 7 days to accept or refuse that proposal. So it's a very strict approach of the law, that it basically allows the mediator to change his hat and put the hat of a conciliator. Right? So even the Italian legislator was not very clear on the difference between mediation and conciliation when they drafted it. Right?
Right.
Many other jurisdictions it is used like that. It is generally
Sure.
used interchangeably, but it is not. They're two different concepts, according to me.
Sure. Sure. Thank you for that, Stefano. Mr. Sanchetti, we have very clear demarcation between mediation and conciliation. But for the benefit of our viewers today, can you briefly explain that, please?
Okay, let me keep it really brief. In court or in arbitration, the judge or the arbitrator is an active decision maker. As compared to that, in conciliation, the conciliator, I am using the term for convenience, is a passive decision maker. In the sense, he follows somewhat of a informal procedure as compared to the formal procedure which is followed in court. He can meet parties individually, etc., which we do in mediation also. And then he can give a proposal that according to me, this is how both parties should settle. If it was a pure money claim, he could say instead of $10 million, we settle it for $5.5 million. And payment terms, interest terms, etc., ABC. But this is a very simple example. It is still open to both the parties to accept the proposal or not to accept it. He is a decision maker, but I call it passive because his decision is not binding on parties. It is up to the parties to accept it or not. The mediator, in contrast with both, is not a decision maker at all. He is only a facilitator, as Stefano said. He is only a facilitator. He does try to go into the underlying problem by meeting parties, by exploring different avenues, jointly or severally. But he is not a decision maker. By knowing the problems, he might say, why don't you think of such a solution? Why don't you think of such a solution? But he is not mandated to give a solution himself. And he is not expected, or it is not warranted of him to give a kind of a solution or a proposal in writing and say, please take it or leave it. He is only facilitator in that sense. Within the role of facilitator, he can be a guide, he can be advising. If he's a seasoned lawyer, he can be advising on that ground. If it is a family member, he can advise on that ground, etc. So, active decision maker, passive decision maker, and only facilitator. If that gives the clarity of picture in relation to the contrast between the two. Incidentally, if you were to go to US, what we do in mediation, they do in conciliation, and what we do in conciliation, they do in mediation.
Right. Thank you for that, sir. I have the burning question which is bothering all of us today, that given this today's situation and due to this impact of this COVID and the resultant economic slowdown, many contracts are being suspended, claiming force majeure or impossibility to perform, and so on. Can mediation be used as an effective dispute resolution method between these parties so that they can move on rather than getting clogged into the court system, which is yet to start functioning fully? And as and when it does, it will still take its own sweet time. So can mediation be used here? And also, in your experience, has mediation been used already? And if it is, then what has been the outcome? Starting with you, Mr. Sanchez, please.
Yes. Well, I dare say that it can be used and it should be used. There's no reason why it cannot be used. I'm not aware immediately of any precedents or any actions being done during these times in last 2 months. I have not come across that. Largely because I'm inactive, being away from Mumbai also. As you rightly said, the core is force majeure results in suspension of the contracts. The question then is about, would it result in cancellation, termination? Would it result in continuation? If continuation, then on what terms, etc. Very often, what would be the duration of the contract now, post majeure completion? What will be the prices? Will there be an impact on the prices? Delivery schedule, or many other aspects which might need some adjustment. A particular commodity may not be available. Imports of something may be banned. Transportation of something may be banned, etc., etc. As long as both parties are willing to do the business together, as long as both the parties are willing to continue the business relationship, I see that mediation can be one of the best tools to work it out. Because it is not always that parties want to take undue advantage and then say no. It is because the situation becomes so different that it is rather impossible to go back to the original position and perform it according to that. So mediation is a process where either party can really come out and say, this is my real problem. I am not able to overcome it, or this is making it impossible, or this is the real difficulty. And then parties together can find a solution for the mutual benefit. So the so-called misunderstanding, which when one party says, sorry, I cannot, or I will not, or I have this, that, and the other, can really be ironed out. Because when you understand each other's perspective better, it really works. So I see no reason, and I highly recommend it that it should be followed.
Thank you, sir. Thank you. Stefano, I would like to approach the same question from your perspective. Are there international disputes that are getting resolved, or would mediation be effective in resolving international commercial disputes given our situation?
Right. Yeah, I think actually, I think that mediation in this period is maybe the only effective dispute resolution tool related to if we look at international commercial disputes, because if we see the contracts that generally are affected by this situation, they all have a force majeure clause, but the interpretation of those force majeure clauses is not the same all over. So depending where the contract, to which jurisdiction the contract is subject, even if the courts were properly working, the dispute would be long and would be possibly not satisfactory for both parties. So mediation in this situation is the only real tool that can be used to have a quick resolution, which is very important today, because if you don't have a quick resolution, then your business is stuck, and when the business will start again, you will be stuck in dispute, and you won't have your proper business suppliers and network in function to support your activity. And I give you a practical example of a mediation that I did 20 days ago. There was this dispute between an Italian restaurant owner and his Spanish supplier of products for the food products for the restaurant, right? The Spanish supplier had not supplied because of coronavirus. He had this logistic platform was blocked, so transport could not reach Italy. So many products were not supplied, right? So the restaurant owner at the beginning was thinking of claiming that like execution or damages, right? And he was basically oriented to claim damages because he perfectly knew that they would not need those products for a long period of time, because restaurants are closed today, right? So what do you claim actually? I mean, you claim damages, but the interpretation of that force majeure clause was not very clear. So it was not the real restaurant owner interest to claim those damages. At the end of the day, the dispute was resolved because, unfortunately, in Italy there are now very strict rules to reopen the restaurants that will reopen actually next Monday, but many of them will not open again because the strict rules of distancing between the tables of the restaurants will not allow them to cover the costs, because they will have many less people going to the restaurant, so the cost would be too high. So this businessman actually is planning to open a supermarket right now. So it's changing. It will probably not open again the restaurant, and it will open a supermarket. So through mediation, we managed, through this separate session that I had with him, exploring this situation that he could not share with the other party, we actually end up with a resolution that with a new contract with the supermarket, for the same product, not exactly the same product, but same range of type of products, with a little discount on the product to compensate the fact that the original products were not shipped, right? But both the provider and the restaurant owner have a new contract, and with the very satisfactory, because of course the supermarket will order more products than the restaurant would have done in these times, right? So that was a quick example of how mediation, and if you bring that to court, the court will only focus on the force majeure interpretation of the force majeure clause and damages, so it would be anyway not satisfactory for both parties. So
thank you for that. That's very interesting, and that only demonstrates how mediation can be very effective and a win-win situation for both the parties. Thank you for sharing that. That brings me to a very interesting follow-up question, and this is something that has been troubling me for a while. Often we hear that complex disputes cannot be resolved through mediations, and it is only meant for smaller disputes and mid-sized disputes which can be resolved through mediation, but not the highest stake ones. So would you comment on that, Stefano? How would you like to answer that? What is your view on that?
well, actually, I think that is I don't see it true. I see it partially true, but I think that we must focus on the fact that mediation mediation is just let's call it the hardware, right? Then an hardware to function must have software in it. So mediation skills, mediation techniques, the techniques of the mediator are the software. So it is possible that the structure of the mediation process, as we all know, may not be suitable for specific complex disputes, like, for example, multinational disputes, or like disputes with a specific issues and specific structure of stakeholders, mainly, that make them very complex, right? And maybe you cannot address them directly with the mediation process. But a good mediator who owns the software of the techniques and the approach, will be definitely able to create a tailor-made process to address that specific dispute. That we can call mediation. Mediation is just a word. We can call it mediation. We can call it dispute resolution, dispute management, as you please. But the principles and the techniques are exactly the same. So any dispute can be solved through a let's call it a collaborative approach. Collaborative approach, meaning the use of mediation techniques and principle adapted to the specific dispute.
Sure. Thank you for that. Mr. Sanchetti, I wanted to draw upon your experience in resolving complex disputes. Sir.
While I agree with Stefano partially, but let me start with a counterintuitive thought. Yes, we all as lawyers say it's a very complex problem, complex dispute. Frankly, I haven't come across a dispute which really is complex. I'll tell you why I'm saying it. To you and me, or all of us as lawyers, if you're doing an oil industry matter, if you're doing an aviation matter, if you're doing a shipping matter, if you're doing a IT matter, it is complex because it's not effortless. For us to first understand, we need hours and hours of content. Then when we do the drafting, we need somebody to look into it, have we technically put everything correct. When we start with evidence, we have issues because we don't know the subject. I've had the good fortune of doing arbitrations in maybe 10 different subjects like this. And each time I was cross-examining an expert on the other side. I said I need two experts sitting by my side so that I'm at par with it. But that is because of lawyers' inexperience in that subject, and lawyer obviously cannot have experience in every subject. If you have, as part of mediation process, a subject expert, I'm talking in the context of what he just said, complex commercial dispute, shipping, aviation, nuclear technology, atomic technology, infrastructure, IT sector. I'm doing arbitration just now in IT sector, where a professor, 80-year-old professor of IIT Mumbai, came as witness on the other side. And for first 2 days, I was only asking him general questions to explain what his subject is. And the arbitrators, the three retired judges were laughing at him. Is it a teaching session or is it cross-examination? I said, without asking him these things, rest is all nonsense. So complex it is in that context, complex it is not for parties. So while you may have a panel of mediators, one of them at least is an expert. If you have that, there's nothing complex. The person knows the subject, he makes it easy for the two other mediators possibly. The parties obviously know their subject well. The subject is not complex for them. I remember about 15 years back in very huge, almost $1 billion aviation dispute. The law lord who was presiding the arbitration with Justice Bharucha and Justice Jeevan Reddy, both ex-judges of Supreme Court, said, I'll finish the whole arbitration in 2 days. Your papers are here. I know ultimately it will boil down to one or two issues. Nobody believed he is so right till it came to evidence, and it came that both the MDs had to file their affidavits only on one issue. Both filed affidavits. None wanted cross-examination. We set for settlement, and second day we settled. So ultimately, as Stefano said, corporations are large, but it is human being who is running the show. So human misunderstanding, human ego, or any such clash, or sometimes just some technical aspect, which parties know the subject well, just somebody needs to be a facilitator. So I'm very positive. I wholeheartedly agree with both of you that it is possible, it is doable, and in real sense, there is nothing which is complex, which needs court's assistance and which can't be done in mediation. The example that I've given is to tell you that if you were to ask a judge to solve it for you, yes, it is that much more complex for him. You have to make it easy for him and you have to spend that much more time and cost for him to understand the subject. So I hope it conveys the right message. Thank you.
Thank you, sir. Thank you for putting it in perfect perspective from mediation and even otherwise from a holistic perspective of looking at a dispute itself. Thank you so much for that. I have a quick question, and because we are conscious of time as well. So, Stefano, starting from you, I wanted to ask the question from both our panelists. Can mediation be effectively done online as of now? And I'll put the context to it because today courts are trying in different jurisdictions to put some kind of a structure in place for online dispute resolution. Even in arbitration, where we are familiar with online disputes, but there also the trials and cross examinations were always done before the arbitral tribunal. There also there is some effort being made to whether take it from the conventions and protocols for online hearing. We are trying to do something there to resolve the disputes online. How about mediation? How ready mediation is today to be resolved online, or it is still a work in progress and we need to come up with a fuller system? Stefano?
Well, actually, I think that mainly the main problem, I mean, online mediation, we have been actually doing it all the time because in our Italian law, there is a specific chapter about online mediation. Mainly because sometimes it's not effective to move from one city to the other to do a mediation when like disputing parties come from different cities, right? So we've been using it, we've been doing it. The structure is in place, there are platforms, there are technology is in place. What I believe that is challenging as a mediator is being prepared to manage mediation online, which is much more difficult than in real media, like where you have parties in front of you. Managing the emotions, perceiving like the frustration of the parties, the possibility of, I mean, their perception, the non-verbal communication that they in the mediation is very difficult on an online platform. I find it very difficult. So that is the challenging issue about online mediation. A mediator should be trained and prepared to do online mediation. First of all, because technology always creates problem, right? So technology is can be a barrier in the human interaction. Both if the parties are not prepared to it, and if the mediator is not able to manage the negotiation the mediation properly on an online setting. And then because you have to consider many issues, like for example confidentiality, the possibility that because parties are in their own private settings, that other people come in place, or that
I think we are losing audio there, Stefano. I'm so sorry, but it seems like we are losing audio. Stefano, you have gone mute. Thank you, Stefano. I think we missed that last part if you are hearing us. And sorry to our viewers that there seems to be some technological disconnect. I would quickly ask that same question to you, Mr. Sanchetti, from your experience and the way you look at it holistically. Can mediation be done online as of today?
Technical glitches apart, which we have just faced, I think it's a necessity. We cannot travel inter-country, we cannot travel intra-country, we cannot travel intra-city, we are not even able to go to our offices. But that does not mean that all business or all activity stops. So there is no reason why the online mediation cannot be done. The age-old saying is necessity is the mother of invention. Inventions we have already. The webinar that we are doing is possibly an available tool for doing mediation online. I don't see any difficulty why it can't be done. Technical glitches just can be there. They have to be overcome. Anything new will have teething troubles, but that doesn't stop it from being used. Nothing begins with a perfection. Everything needs to be improved. So the larger issue which Stefano raised was really about emotional. How do you read the emotional feel of the person who is sitting for mediation? Because everything else is a matter of communication. Whether everybody is online together, some are offline, some are muted, some are speaking, some are seeing, some are not seeing. All this is now possible. That's not difficult. Only aspect is when you sit with somebody one-to-one, maybe you understand his feelings, his emotions better than when you do it online in this fashion. But I'm sure if need be in a given situation, and if you were to say that I'll put everybody else offline and I'll speak to this person one-to-one, a substantial amount of it also can be covered, not fully possibly, but it can be covered. And given that, if in every other field, my father had a heart problem and I was consulting a doctor, including exchanging ECG, and everything else, everything on WhatsApp. And in 15 minutes, the whole issue was resolved. So if it is a necessity, it is. And if you have to solve it, you have to. So I see no reason why we should not use it and why it cannot be used.
Thank you for that, sir. It's very encouraging because we do need that. We do need quick and effective dispute resolution process in today's time more than any other times, and
Yes,
especially
yes,
for commerce and for business where things have to move on. It's like an ongoing activity. It has to be quick. So it will be very,
yes.
very useful if mediation can be done online and in today's situation. Unfortunately, we are running out of time. I could have gone on, and that only demonstrates to the viewers the vast experience both the panelists have. So I would conclude this part by thanking both of you, Mr. Sancheti and Mr. Cardinale, for coming and sharing these in-depth uh, propositions with regard to mediation. We do have a few questions from the audience. If I can request quickly, I'll read it out. And if I can request both or either of you to just take it up. One question that we have received is, could you kindly speak about the necessity of a legislation in mediation, at least in order to secure the confidentiality of the data? This is by Alban Anto. So, since Italy already has legislation, may I ask Mr. Sancheti on this?
Uh, Very valid question. I very briefly touched it also. In relation to conciliation, the Arbitration Act has specific sections dealing with confidentiality. I completely agree with you that the same degree of confidentiality is required in mediation. The Maharashtra rules or even some other rules do give almost the same, not exactly the same, almost the same degree of confidentiality. But a law is any day better than the rules, because when we are sitting for negotiations under mediation, people should have the complete freedom that whatever I say or whatever I quote, whatever I express is not used as evidence in court against me. And I'll give you one example. Of course, that was of conciliation, but the importance. In a oil industry related matter where the claim was few $1 million, they went to a set of conciliators. They proposed a settlement. One party said yes, the oil company said no, but we are willing to give you 80% of what they have suggested for reasons ABC. That party accepted it. They all signed the document and they went, they paid the money. Now the party which received the money wanted to go for arbitration for the remaining claim. And judge of the Bombay High Court at that time, who is now sitting there in Supreme Court, said this: if he feels that something more was suggested, or if he feels his claim is more, I'm not granting it. I'm only referring it to arbitration. I had to only then show in detail what these provisions are and why you will be doing a great disservice to the entire process of conciliation of mediation. Because if people, after settling in mediation conciliation, were to show all this and go for arbitration, then nobody would settle. So I completely agree with you. In some form or the other, that confidentiality aspects need to be fortified further.
Thank you, sir. And I think there is another follow-up question by the same person. Could you please explain the challenges to data confidentiality in the process? I think this is already covered by Mr. Sancheti. Another, then we have question from one more question. Stefano, would you like to answer this? The question is, what is the difference between impartiality and neutrality as far as the mediator is concerned? This is question by Chitra.
Well, actually, partiality and neutrality are the two faces of the same coin, right? So, when I mediate, I must be both neutral, meaning that I am not, I must not be more favorable to one of the parties or to the other party. Meaning that even not only my being neutral is important, but I must be perceived as neutral by the parties, because mediator has no power of imposing any solution. So as no, a judge has a power to impose a sentence, an arbitrator has the power to impose an arbitral award. So mediator has no power about it, has no power to impose anything. So if parties don't perceive a mediator to be neutral, then they will not settle. That mediation will be completely useless, right? So neutrality is important, both being neutral and being perceived neutral. Impartiality, we intend impartiality as not having, and that is, for example, in Italy, specified in the law and in the ethic code of lawyers when they act as mediators. You must not have any stake in the dispute, not in the dispute, not even in the businesses of the parties involved in the dispute. So, for example, in the Italian law, it is stated that if I have been counseling one of the parties in the past 2 years, then I cannot act as a mediator if that party is as party of the of the mediation, because it is considered that I've been lawyer of that party, and so I cannot be impartial in that mediation.
Sure, thank you for that. Sir, Mr. Sanchetti, there is a specific question which many of our viewers have asked, and I'm just going to read it out. Is there any issue in enforcing settlement agreements arrived at in mediation? This is asked by a number of people, including Mr. Manish Asarkar.
Yes, I was expecting that, because conciliation settlements are treated as an arbitration award. They are deemed to be award. Mediation, because there is no law on that, mediation settlements do not have that level. But that does not mean that mediation settlements are of no value, because if it is a court-referred mediation, then the mediator will give his report to the court. If there is a report with a settlement between the parties, then the court will pass a decree in terms of settlement. So no issues at all. But supposing it was a mediation pure and simpliciter and not gone anywhere, party can still have it formalized in the form of an award or in the form of a decree by formally adopting proceedings. If the confidence level is much higher, the mediation settlement in any case can be a full-blooded contract, which by itself is enforceable. So these are the three different possibilities.
Thank you, sir. We have already run out of time and way beyond. So we have two more questions. I mean, I can try and club them together. Very quickly, Stefano, in a minute, question is very long, but I request you to try and
Right.
Sure. The question is, what advice would you give to an advocate who is representing his client in a court-directed mediation? Specifically, how one can manage their client's expectation when at the initial stage of court proceeding, one has represented that client that actually he has a good case on merit. But now he's supposed to expect a lesser settlement.
Right. First of all, I would not say that the mediation is aims to a lesser settlement. That is not the right perspective. I mean, maybe a different settlement, maybe a different way to reach the interest of the client. But the interest of the client must be met. Otherwise, there is no. Otherwise, mediation is not effective. So we need to train actually our clients to understand the scope of mediation, because once you understand that, then it's then it's the same. It's the client who want to go for it. I mean, the first negotiation is with the client. As a lawyer, always our first negotiation is with the client. So it must be on that also.
Thank you for that. This was from Ms. Narayan. And now the last question, since it's like I know I have taken much more than scheduled time from both of you. And this is specific for Mr. Sancheti. Sir, the question is, in your experience as a mediator, have you had a situation where you feel that A party's proposal is fair, but other parties is not accepting, thus making resolution difficult? And
Yes.
perhaps in such situation, what is a mediator supposed to do? Persuade the party to resolve, or convince a party that it is an ideal situation to ideal proposal to accept?
Well, the situation is very real. It does happen off and on. So whoever has asked it probably has experienced it. The mediator's position is very fragile in that sense. He doesn't want a situation where parties go without settlement. He also cannot force parties to do the settlement. So, at least in my experience, and what I do is pursue both the parties, make them feel why what somebody is saying is reasonable, and maybe tell the other party also that why can't we make it a little more reasonable for the other person in that sense, because you have to be away from being judgmental. You have to tell them both that it is not about who is right, who is wrong, and push it forward on that count. Thank you.
Thank you so much, sir. We have questions pouring in, and now I'm going to request all my viewers, please do send us emails and please let your questions come. I'll request both the panelists if they can kindly answer the questions to the best of our the ability. We'll try and reach out to you and respond. Well, Mr. Sancheti and Mr. Cardinale, thank you so very much for joining this and for giving us that in-depth complete overview of the mediation process and how this can be used effectively in this today's situation and its relevance for resolving the commercial disputes. Thank you so much and stay safe, sirs. Take care. And to all our viewers, thank you so much for joining us. Stay safe, take care, and bye.
Thank you.
Thank you, Mr. Chakrapani. Thank you very much for giving us this opportunity.
Thank you, sir.
Thank you.
Bye.
Bye, sir. Bye, bye.